The government is attempting to turn the tragedy of Crystal's death into the travesty of prosecuting Mr. Rash for her death. And at the end of this case, my partner, Merle Josty, will come before you and ask you to end it once and for all.
Tragically killed herself instantly. That sentence was spoken at the start of a first-degree intentional homicide trial, not by the defendant, not in a jailhouse letter, by a licensed attorney in front of a sitting judge, before a seated jury, as the official defense position in a case the state of Wisconsin spent months building. Think about what that means for a moment. Picture a scale. On one side, a prosecutor telling a jury they are going to prove intentional murder. On the other side, a defense attorney standing up in the same courtroom and saying, on the record, that the state cannot even prove who pulled the trigger. That scale is not balanced. That scale is the entire case. Before we go deeper into what the documents actually show, make sure you're subscribed to Law and Rule, because we don't just cover the story, we follow the evidence. Here is what the public record tells us. Zachariah Rash and Crystal Rash were estranged spouses heading toward a divorce hearing.
They had a divorce trial, a divorce hearing set for August of 2024. And by and large, it was going to be the end of their marriage. But they still spent time together. They had children together.
Scheduled for August 2024. They had children together, children the state of Wisconsin had.
And then, no doubt, Crystal loved her children. And no doubt, she also had a looming date to determine what is going to happen with her children.
Removed from both of them. Those children had been in foster care for 5 years.
5 years with a foster mother at this time, developing relationships and moving forward. And adoption was on the table. It's a zero-sum game, adoption. Someone's going to have the children and somebody...
Adoption was on the table. That is not a detail. That is a motive the prosecution never owned, and the defense never let the jury forget. Someone was going to lose those children permanently, and both parents knew it. On June 8th, Zachariah picked Crystal up. Over the following days, they spent time together at a family property in Adams County, near Wisconsin Dells, his grandmother's land, wooded, private, frequented by relatives. By the defense's account, they behaved as a couple. They ate together in town. They existed, briefly, as if the divorce wasn't 3 months away. On June 11th, they drove to Milwaukee. The Google searches are in the record. The cell phone location data is in the record. They were looking for...
Crystal did have an attorney at the time, but you'll see from the Google searches that they Googled attorneys in Milwaukee and that their cell phone records show that they were there. But they couldn't get into...
Attorneys. Not individually together. They couldn't get a meeting. They drove home. Something happened on that drive home. The prosecution says Zachariah Rash killed his wife in that car with his own 9mm firearm. The defense says Crystal Rash was handling that firearm herself.
As he was driving, the gun discharged. And then he drove to his property in Clyman and began a series of incredibly...
And it discharged. The prosecution's own opening statement, according to the defense, conceded they do not know what caused the death. Read that again. The charging party in a first-degree intentional homicide case told the jury, before a single witness testified, that they do not know what caused the death. That is not a gap in the evidence. That is the case. What happened next is not in dispute. Zachariah Rash panicked. He drove to his property. He disposed of Crystal's remains. He used sulfuric acid. Her remains were found in a burn pit at a...
Their remains were found in a burn pit and also covered with sulfuric acid. We will have few questions for a lot of these witnesses that are going to come forward and testify to that. The forensic anthropologist, the dentist.
Property on Wood Road. He lied to friends. He lied to family. He created false Facebook accounts. He used her bank card. He lied to police. The defense said all of this out loud, unprompted, in their opening statement. Here is where this case stops being a domestic tragedy and starts being a question about the architecture of the criminal justice system itself. The state of Wisconsin is charging intentional homicide. Intentional. That word has a legal definition. It requires the prosecution to prove not only that Zachariah Rash caused Crystal's death, but that he caused it on purpose, with...
Number one is that Mr. Rash caused Crystal Rash's death. Two, that he caused her death intentionally. The prosecution has no
intent to kill. Two separate burdens. Two separate mountains of proof. Both must be climbed beyond a reasonable doubt. The defense is not arguing Rash is a good man. They are not arguing the cover-up didn't happen. They conceded the cover-up completely. What they are arguing is surgical and specific. Can the prosecution rule out that Crystal Rash shot herself? And if that question has no definitive answer, if the forensic record cannot eliminate that possibility, then by the legal standard that governs every criminal trial in this country, the answer has to be not guilty. That is not a technicality. That is the Constitution. Now here is the question nobody in mainstream coverage is asking. If the prosecution cannot establish cause of death with certainty, why was this charged as first-degree intentional homicide rather than a lesser offense? What does it mean when a charging decision appears to be driven by the severity of the cover-up behavior rather than direct evidence of the killing itself? Because cover-up is not causation, panic is not intent, and burying evidence of something you didn't do looks exactly the same as burying evidence of something you did. That is not a gap in the evidence. That is the case. The defense laid out 3 questions for the jury to carry through every witness, every exhibit, every piece of testimony. First, what element of the offense does this evidence actually prove? Second, can the prosecution rule out that Crystal Rash shot herself? Third, if any lingering doubt remains about cause of death, that lingering doubt is, by definition, reasonable doubt. 3 questions, not 12, not 100. 3. And here is the part that should make every person watching this stop and sit with it. A forensic anthropologist is going to testify. A forensic dentist is going to testify. Both will confirm identification of Crystal's remains and the conditions in which they were found. The defense told the jury up front, we have almost no questions for those witnesses, because those facts are not the fight. The fight is the moment before the body. The fight is inside a moving vehicle on a Wisconsin highway, with 2 people in crisis and 1 firearm between them, and no camera, no audio, no eyewitness, and a prosecutor who already told the jury they don't